MP, the member for Kitui South constituency, the Honorable Gadhoni Wamshomba MP, the member for Githunguri constituency, and the Honorable Zamzam Mohammed MP, the member for Mombasa County, and many other members spoke on the matter. Notably, honorable members, the Honorable Sabina Chege observed that her proposed removal from the position of the Deputy Minority Whip was contrary to Article 47 of the Constitution, which grants every person the right to administrative action that is lawful, reasonable, and procedurally fair. Additionally, the Honorable Chege was of the view that the proposed removal contravened Article 236(2)(b) of the Constitution, which requires that due process of law should precede any removal from office. Honorable members, I wish to inform the House that since reserving this matter for a considered ruling, my office has received further correspondence from the Jubilee Party, signed by the Honorable Kanin Kega as the Acting Secretary General of the party. In the correspondence, the Honorable Kega has conveyed certain changes to the leadership of the party, including the appointment of a new party leader. The letter raises issues on who the bona fide officials of the party are. I note that the letter is copied to the Registrar of Political Parties, who I trust will exercise her mandate appropriately. Honorable members, from the foregoing, I have distilled the following three issues requiring my guidance. One, whether the proposed removal of Honorable Sabina Chege as the Deputy Minority Whip is contrary to Articles 47 and 236(b) of the Constitution and the due process of law. Two, whether the proposed replacement of the Deputy Minority Whip complies with the standing orders of this House. And three, whether the Jubilee Party is a parliamentary party within the meaning of the standing orders. Honorable members, at this stage I shall refrain from addressing the first issue that I have isolated. This is because the issue touches on matters falling partly within the mandate of the House and partly within the mandate of other competent constitutional and statutory bodies. These bodies include the Judiciary, the Political Parties Disputes Tribunal, and the internal dispute resolution mechanisms of political parties and coalitions. Honorable members, the centrality of the Bill of Rights is in the architecture of our Constitution cannot be gainsaid. Indeed, human rights are one of the national values and principles of governance under Article 10 of the Constitution. Article 47 of the Constitution on the right to fair administrative action, and Article 236(2)(b), of the Constitution, which requires the due process of law to be followed before the removal of a hold of an office, finds their basis in the Bill of Rights. These rights accrue, honorable members, don't worry about that. These rights accrue to every person, including members of this House, and cannot be limited except in the manner provided for under Article 24 of the Constitution. Honorable members, whereas Article 22 and Article 165 of the Constitution confer the exclusive jurisdiction to determine the question of whether a right or a fundamental freedom in the Bill of Rights has been violated, Article 3 of the Constitution obligates the Speaker to uphold, defend, and respect the Constitution. It is noteworthy that under Article 20 of the Constitution, the Bill of Rights binds all state organs and persons. Pursuant to Article 21 of the Constitution, every state organ is under a duty to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. In this regard, where a question arises touching on the possible violation of a member's fundamental right or freedom, the Speaker cannot fold his arms and fail to act in blindness of the express requirements of the provisions of the Constitution and that I have cited. However, honorable members, I have observed earlier, addressing this issue exhaustively requires the involvement of other competent constitutional and statutory bodies besides the Speaker. Whereas the Speaker may make interim interventions to facilitate the continuity of the business of the House, the final interpretation and enforcement of the rights and freedoms lies with the judiciary as outlined under Article 165 of the Constitution. Honorable members, on the second issue, I note that Standing Order 20A4 provides that a decision of a parliamentary party replacing its whip or deputy whip shall be communicated to Speaker in writing. In the case of the minority party, the decision is to be communicated by the leader of the minority party. Please note the emphasis of the standing orders on the use of the word replacing. Further, Standing Order 20A5 obligates the Speaker to convey the decision of a party to replace its whip or deputy whip as soon as practicable following receipt of the decision. Members at the door, take your seats. Take the nearest seat. Take the nearest seat, honorable member. Thank you. Further, Standing Order 20A5 obligates the Speaker to convey the decision. I had read that. Honorable members, in most multi-party democracy, jurisdictions all the world over, party discipline is key to the very existence of political parties. It may rightly be said that without party discipline, the functionality of political parties and multi-party democracy would be prejudiced. Permit me to note that Standing Order 20A finds its basis in Article 4.2 of the Constitution, which establishes Kenya as a multi-party democracy. Additionally, paragraphs 4 and 5 of the Standing Order on replacement of party whips are in line with the democratic right of parliamentary parties to enforce party discipline of its members as provided for in the Political Parties Act 2011. Honorable members, from a close reading of Standing Order 20A4 and 5, it is evidently clear that the Azimio La Umoja One coalition is fully entitled to discipline its members and to determine the composition of its leadership in this House. The only condition to the exercise of this right is that it has to follow the process prescribed under the Standing Order 20A. Excuse me again. Honourable members, I have a bit of cold, so bear with me. Standing Order 20A. Pardon? Yes. 20A. Honorable members, during yesterday's afternoon sitting, the leader of the minority party submitted that the Speaker should not be seen as interfering with the manner in which a parliamentary party elects to organize its affairs. I cannot agree more, and I have no intention of interfering with any party. Indeed, honorable members, this is the accepted practice, particularly in the Commonwealth. Honorable members, an examination of precedents from parliaments in comparative jurisdictions lends itself to the adoption of a delicate approach in resolving internal party matters in the chamber of the House. In New Zealand, the arrangements for the appointment of whips are internal matters for the respective parties to determine on condition that the Speaker is advised of the appointment of whips. This is from the Parliament of New Zealand, Standing Order 35(1)B. Similarly, in South Africa, the National Assembly of South Africa was recently confronted with the leadership and decision-making dispute in the Pan-Africanist Congress of Azania Party. In the matter, PSC had one seat in the National Assembly which was filled by the nomination of a certain Honorable Nzwanele Nyoto, who had already been sworn in as the party's representative in the House. Subsequently, honorable members, a dispute arose within PAC or PSC regarding its leadership, and there was uncertainty about communicating the membership of Honorable Nyonso and consequently who should represent the party in the National Assembly. The guidance provided to the House by the Speaker was as follows, and I quote, "The Speaker has no authority to adjudicate internal party disputes about membership to the National Assembly or its leadership. Neither the Speaker nor the House gets involved in political party matters. It is neither for the Speaker nor a House of Parliament to decide which is the legitimate leadership structure of a political party. It would be incorrect for either the Speaker or the House to recognize one structure as the legitimate leadership of a political party, the PSC, over another." Honorable members, you'll agree with me that the foregoing guidance of the Speaker of the South African Parliament is relevant to the questions that confront us today, including the question which formation of the Azimio coalition or the Jubilee Party the Speaker should recognize in this House. Honorable members, the determination of political party disputes is best left to the competent authorities outside Parliament as envisaged by law. This House passed the Political Parties Act, whose provisions you are all aware of. The House, or indeed the Speaker, ought not to be called upon to arbitrate party matters. In the case of party leadership in the House, the Speaker only communicates party decisions as received through the authorized persons. It should not be lost to us that the question of who the authorized persons are with respect to the Jubilee Party is one of the issues lingering. Honorable members, party whips are and have been an invaluable cog to the continuity of parliamentary business. Erskine and May, a renowned authority on parliamentary procedure, notes that, and I quote, "The efficient and smooth running of the parliamentary machine depends largely upon the whips." Erskine May further outlines the nature of the duties undertaken by whips that makes them deserving of this lofty status, and in this regard, Erskine May also notes, and I quote, "Certain duties are common to whips of all parties: to keep their members supplied with information about the business of the House, to secure the attendance of members, to arrange, when possible, for those of their members who cannot attend divisions to pair with others on the opposite side of the House so that their votes might not be lost, to suggest members to serve on general and certain select committees, to act as intermediaries between the leaders and the parliamentary membership of their parties in order to keep each informed of the views of the other." Honorable members, this authority creates a very strong nexus between facilitation of the business of the House and the office of the whip or the deputy whip. In this regard, I am of the considered view that the standing orders of the National Assembly are deliberately worded to ensure continuity of parliamentary business. A close reading of Standing Order 20A leads to the inescapable conclusion that once a parliamentary party has designated a whip or a deputy whip, the only subsequent change that the parliamentary party may make with regard to the two positions is a replacement of the person designated as a whip or deputy whip. Honorable members, according to the Oxford Learner's Dictionary, the word replace means to remove someone or something and put another person or thing in their place. It therefore follows that a replacement has two components: the act of removal and the act of substitution, which must happen simultaneously. Honorable members, in the current scenario, the minority party has conveyed its decision seeking to remove one of its leaders without simultaneously offering a substitution. The letter by the minority party only partially meets the express requirements of the standing orders. Honorable members, the Speaker is also confronted by several correspondence from a constituent party of the minority party that is currently facing its own internal disputes. Any speaker would be highly constrained to facilitate the continuity of the business of the House in an environment which raises pertinent questions that cannot be ignored, including: 1, should the Speaker ignore correspondence that affects the rights of members who collectively meet the threshold to constitute a parliamentary party? 2, should the Speaker take cognizance of the President of the House on access to pre-election and post-election coalition agreements affecting its leadership? Honorable members, to my mind, the matters at hand cannot be conclusively resolved without affording the affected parties adequate time to comply with the procedural requirements outlined in the standing orders. The affected parties basically have to put their affairs in order. The National Assembly is a house of order. Consequently, the minority side and the Jubilee Party must organize their affairs and also endeavor to appear organized. As per the calendar, honorable members, as per the calendar, the House is scheduled to adjourn at the end of the sitting today for the May recess. I'm inclined that we allow the minority party and the Jubilee Party 30 days within which to put their affairs in order. By the time the House resumed from the recess, it is my expectation that my office shall be in receipt of communication from the minority party, replacing its minority whip, if they so wish, in the manner contemplated under Standing Order 20A. Honorable members, the third issue for determination is whether the Jubilee Party is a parliamentary party within the meaning of the standing orders. You will recall that in his letter seeking the recognition of the Jubilee Party as a parliamentary party, the Honorable Samuel Aram observed that Article 36 of the Constitution on Freedom of Association and Article 38 of the Constitution on Political Rights confers upon each member of the House the right to determine which entities they wish to be associated with and the right to make political choices. Honorable members, Standing Order 2 defines a parliamentary party as a party recognized by the Speaker as a parliamentary party pursuant to Standing Order 20A, recognition of parliamentary parties and designation of leaders and whips. Standing Order 20A1 provides that the Speaker shall recognize a party or coalition of parties consisting of not less than 5% of the membership of the National Assembly as a parliamentary party. Honorable members, 5% of the membership of the National Assembly is 18 members. From the records that the House has and the Speaker's office has, the membership of the Jubilee Party in the National Assembly comprises 28 members. 28. In this regard, and pursuant to Standing Order 2 and 20A1, the Jubilee Party meets the threshold to be recognized as a parliamentary party. Whereas the Jubilee Party meets the threshold to be recognized as a parliamentary party, however, I am hesitant to invoke the provisions given the myriad correspondence received from the party with respect to its leadership and the persons authorized to communicate on its behalf to the Speaker. Honorable members, in summary, my guidance is as follows. 1, that the communication received from the minority party with regard to the replacement of the Honorable Sabina Chege as the deputy minority whip is incomplete and therefore does not comply with the requirements of the Standing Order 20A of the National Assembly's standing orders. 2, that I hereby grant the minority party a period of 30 days from today within which to convey appropriate communication on the replacement of its minority whip if it wishes. 3, that whereas the Jubilee Party meets the threshold to be recognized as a parliamentary party pursuant to Standing Order 20A1, I am hesitant to invoke this provision given the myriad correspondence received from the party with respect to its leadership and persons authorized to communicate on its behalf to the Speaker. I also give them a similar time to put their house in order. Honorable members, I take this decision conscious of the fact that as your Speaker, my duty is to uphold the Constitution, any law, and the standing orders to the extent to which they relate to the management of the business of the House. It is not the duty of the Speaker to be involved in the management of the internal affairs of any political party and the Speaker does not wish to do so. I thank you. Yes, Robert Mbui.
Yeah, thank you, Mr. Speaker, for that ruling. Mr. Speaker, I do agree with a lot of the things that you've said, but Mr. Speaker, it's important to note that you yourself has confirmed that our standing orders, Article 20, is very clear about the removal, and the word you have used is the word replacement. Mr. Speaker, the minute a process begins, and part of that process has already been implemented by the coalition, I'm surprised that that does not meet the standards of removal, because replacement starts with removal. So, Mr. Speaker, I am a bit concerned about the ruling, because, Mr. Speaker, we are going now on a recess. And, Mr. Speaker, you've seen that we've been sitting here, a few of us. And you know that in the recess period, Mr. Speaker, we will still be transacting the business of the Azimio coalition. And we require the whips to be able to assist us. Mr. Speaker, why don't you please allow that we be given an opportunity to look for the replacement, because we have already communicated the removal. You allow us that we give the replacement, if possible, today, but allow us the removal, because that is what we communicated, Mr. Speaker. That is all we are asking, that you allow the removal and then allow us an opportunity to provide the replacement, Mr. Speaker.
Honorable Mbui, the ruling is very clear. I have given you a clear direction. Go and make the correct communication. And I've given you the period within which you are in recess. And the ruling of the Speaker is not subject to debate and will not be qualified. Thank you. Honorable Minority Leader.
Thank you, Honorable Speaker.
You are about to comment on something you didn't hear.
No, well, I had a substantial part of the communication as Speaker. I was standing there. You did notice me. I was from some other meeting.
Okay.
To do with the bipartisan engagements.
Go ahead.
Mr. Speaker, what the gist of your ruling has got two legs. One, if I heard you correctly, is that...
You have a duty to hear me correctly.
Yes, is that the Azimio coalition needs to go back and put its house in order. That is one. And two, that relax, Honorable Chepkonga, just relax. And the two is that under the standing order 20.
Sorry, there's a point of order from...
But I'm on a point of order.
Mr. Speaker. Mr. Speaker.
No, you are not on a point of order. I just gave you time to speak.
Thank you, Mr. Speaker. Mr. Speaker, you know that's why you said the minority leader was not here. So he is seeking to comment on something that he did not hear. Mr. Speaker, what he is saying, you never said. You never said. He says he had 50%. So the other 50% he never had. So he is misleading himself. Secondly, Mr. Speaker, I note my very good friend, Mr. Honorable Mbui, and both of them, Mr. Speaker. I know they are not lawyers. In the strict terms, once a ruling has been given by a court of law, and as you know, Mr. Speaker, you have the powers of that of a high court. Once the high court, once the judge has delivered a ruling, if you are unhappy, Mr. Speaker, you can go and appeal. But there is no appeal here, Mr. Speaker. You cannot sit on an appeal. You cannot sit on an appeal on your ruling, Mr. Speaker.
You are right.
You know, Mr. Speaker, you are a very respectable lawyer. You should not allow anybody to comment on your ruling at all. In fact, you should rule them out of order. Mr. Speaker, this will be the first one in the Commonwealth where the ruling of a speaker has been appealed on and the speaker himself is sitting on an appeal. Mr. Speaker, it doesn't happen. In the common law. It doesn't happen.
Order, honorable members. The honorable Chepkonga is right, but I've given Honorable Wandai I believe that you are not challenging the ruling. Neither are you.
You know, Mr. Speaker.
Yes.
I have been in this House now, this is my third term. The Honorable Chepkonga had the misfortune of missing the last term. So he needs to relax. Mr. Speaker.
Yes.
My point was.
Make your point.
My point was that on the second matter of my communication to you with regard to the replacement of the deputy minority whip not being complete. The Speaker, with all due respect, we have a difficulty agreeing with that position. But be that as it may, the Speaker, that as it may, the Speaker, once we initiate the process of replacement of our deputy minority whip, understanding Order 20A, it would have been advisable that you confirm first the removal of the Honorable Sabina Chege to give us opportunity to make her replacement form.
Order, Honorable Andai. Order. Take your seat, please. The ruling has been very clear. It needs no interpretation. The wording of the standing order is plain English. It talks of replacement. Your letter talks of removal. Removal is not replacement. Replacement is to take out one and put in the other. I have said that very clearly. And your right to do that has not been taken away. And you will not be engaged in either analyzing, that you can do out there in the coffee shop, but not on the floor. Analyzing the ruling of the Speaker, that is not allowed under standing orders. Challenging the ruling of the Speaker, that is not allowed. And in any case, you have said you only had part of it. I'll avail the whole of it to you to read and understand it, and then you can make your comment. You can write to me if you wish. Majority Leader.
Thank you, Honorable Speaker, and let me begin by congratulating you on that otherwise Solomonic ruling. Honorable Speaker, it's clear that as much, Honorable Speaker, that you are not in this House when we enacted these standing orders, Honorable Speaker. If I can allow those walking out to do so quietly. Thank you, Honorable Speaker.
On Majority Leader.
Honorable Speaker, I was congratulating you for having interpreted these standing orders and appreciating that you are not a member and you are not the Speaker in this House when we enacted these standing orders in the last revision in the last Parliament. But Honorable Speaker, as you've said, Standing Order 20A4 is quite clear that a decision of parliamentary party replacing its whip or deputy whip shall be communicated to the Speaker in writing. And indeed, Honorable Speaker, that is the right interpretation. Honorable Speaker, I just want to draw reference or equate this to a football match. When you substitute or you replace a player, you do not remove and do not put in another player to play. And therefore, that was a gist of this Standing Order 20A4, that you shall not remove without replacement, but you shall replace, as is akin in football matches where you substitute a player. Therefore, either the minority or the majority, if the majority wants to replace their leader of majority or their deputy whip or their whip, we replace, we do not remove. And Honorable Speaker, it's also true that power abhors vacuums. And what we were being asked to do is to remove and leave a vacuum, Honorable Speaker. And I really want to ask our colleagues, Honorable Speaker, to be patient and exercise patience. You have already said, Honorable Speaker, that nothing stops them, even tomorrow, from writing to you and express their desire to replace any member, be it in a committee or in their leadership. Therefore, Honorable Speaker, I just want to implore our colleagues to exercise patience to also conduct the affairs of this House with less emotions, Honorable Speaker. Only yesterday, Honorable Speaker, when the Honorable Leader of Minority raised that issue on the floor. I remember, Honorable Speaker, when you tried to stop him in his tracks because he was doing it at the wrong time, the Leader of Minority became very emotional. The Honorable Atandi uttered some unpalatable words, just like I've heard the Honorable Rosa Buyu utter today, like the Honorable Babu Owino was trying to do. Honorable Speaker, we need to conduct this House with some decorum, Honorable Speaker, including when you want to raise a point of order, you do not shout from your seat. You invite the Speaker's attention, Honorable Speaker,